afternoon, and welcome to the Cato Institute. My name is Tim Lynch. I'm the director of Cato's Project on Criminal Justice. And today we want to examine some distressing legal trends that are at work in the criminal law area. Our guest speaker today, Sidney Powell, has just written a new book entitled License to Lie, Exposing Corruption in the Department of Justice. And the book recounts several cases in which ambitious prosecutors used illegal and unethical tactics to win their cases. Now, before we get to our panel of experts, I want to take just a minute or two to lay something of a foundation for the discussion that's going to follow. But before I do that, let me ask those of you who came with cell phones, if you just take a moment now to quickly double check and make sure that they are turned off as a courtesy to our speakers. Yeah, it includes our panelists with that. Okay, thank you. The first point that I think needs to be understood is that there has been incredible growth in the federal criminal system over the past 30 years. In 1980, there were about 1,500 federal prosecutors. Today, there are close to 8,000. Second, there's also been an explosion in the number of federal crimes that are on the books. We know that there are about 4,000 federal statutes on the books right now. But when you take into account all of the federal regulations that are churned out by the regulatory agencies, we're talking about tens of thousands of more regulations that can be enforced through our criminal system. I thought there was a telling moment at the Supreme Court just a few years ago. A representative from the Department of Justice was up before the justices, and he was explaining the scope of just one of these federal statutes. And as he was explaining the scope, he was interrupted by one of the justices. I think it was Justice Stephen Breyer. And Stephen Breyer said, just a second, I think there's about 200 million Americans in the workplace, and according to your definition of the honest services criminal statute, about 150 million Americans fall on the wrong side of that line. And this was a point where the attorney from the Solicitor General's office, he kind of hemmed and hawed. He didn't really deny the point. Now consider that for just a moment. In the eyes of the federal government, we have 150 million Americans that they consider to be criminals. And that's just one of these federal criminal statutes. As I said, there are thousands more. The spider web of regulations is now so vast that it's really hard for an ordinary citizen to go about their lives without breaking some rule or regulation. This is just not the same America that we grew up with. A lot of us in this room, I think, can remember an expression when we were growing up. It said something like, let's not make a federal case out of it. But that expression is really losing its force given the growth of our federal criminal code. Now, we also have to worry about situations where people have actually not violated any one of these rules and regulations, but have nevertheless been targeted by, so let's say, an unethical federal prosecutor. The lives of these people are turned upside down. Their businesses fail, their families are shattered, and their life savings ends up going to attorneys and law firms that are trying to defend them. As a matter of fact, their own attorneys often advise them to plead guilty even when they have met with their client and are convinced that they are innocent. A lot of people say, how can that be? Why would that happen? These attorneys will argue that the alternative is even worse. It's too risky. We're talking about complete bankruptcy if you don't plead guilty early in the process, because the case will drag on. More money going to the attorneys, and even a longer jail sentence if the jury chooses to believe the prosecutor rather than their version of events. So these are some of the problems that our panelists will be addressing, along with some specific cases. Our format is going to be straightforward. Our guest author is going to go first and speak on the thesis of her book. I will then introduce our guest commentators. And after their remarks, we will then open it up and take your questions for about 15 minutes before we adjourn for a luncheon upstairs. Okay. Sidney Powell served in the Department of Justice for 10 years under U.S. attorneys that were appointed by both political parties. During her career in the department, she taught courses on criminal trials and appeals to other prosecutors at the Attorney General's Advocacy Institute. She has been the lead counsel in more than 500 appeals in the federal courts, and for the past 20 years, she's been in private practice representing clients ranging from federal judges to international corporations. She's been repeatedly rated by her peers as one of the best lawyers in America, so she is well qualified to discuss prosecutorial ethics. So would you please welcome the author of License to Lie, Sidney Powell.
Thank you all very much. Thank you, Tim, and I want to thank the Cato Institute for hosting this event. It's very much appreciated. And thank Judge Kozinski for joining us, and also Ron Weich. This is a very auspicious occasion. I think I'm going to start with the foreword to the book. It is written by one of our panelists. Judge Kozinski was kind enough to write that for me because the issues discussed in the book are fundamental to the fairness of our legal system. The main premise underlying the book is that prosecutors have an ethical and legal and constitutional obligation to disclose evidence that is favorable to the defense. There are legal reasons for it. The Supreme Court held in Brady versus Maryland that it's a constitutional obligation fundamental to due process. And then as a practical matter, prosecutors have all the cards. They are their representatives, the agents, the police officers, whoever, are the first people on the scene if there is an immediate crime, or they're the ones who have conducted an investigation into allegations to begin with, or put together all the pieces to charge a crime. They have control of the evidence, they have control of the forensics, they have control of the expert witnesses, and in the cases discussed in the book, they had even more control than that. One of my challenges today will be to talk to you about the book without spoiling any of it for you, because I do want you all to read it. It's written like a legal thriller. I wanted people to be able to read it who are not attorneys, and to find it, and for attorneys also to find it interesting and be held by it so that you can continue reading all of it. But it is all true. It contains real transcript excerpts. One person recently asked me if I had embellished. He said he was giving me about 10% leeway to embellish for the sake of, making it interesting. And I said, I hate to tell you, I actually toned it down. It's not embellished. So with that in mind, there are a number of things from the book that I will share with you. Robert H. Jackson was one of our great Supreme Court justices, and as Attorney General, he gave a speech on April 1, 1940 that has been enshrined in legal history. He talked about the special role of a federal prosecutor and how important it is for that prosecutor to seek justice and not convictions. He explained that at its best, a prosecutor is one of the most beneficent forces in our society, but at his worst, he is one of the worst because he has such complete control over what can happen to an individual and such broad discretion. A prosecutor can indict someone, he can have the case processed quietly and secretly, or he can expose it all to the public and humiliate and degrade the person as much as possible through the process. He has control over where the person goes to prison to a large extent. The government likes to say only the Bureau of Prisons decides that, but that's not accurate at all. The prosecutor has a lot of input in that regard, and particularly in the cases discussed in the book, that's true. But yet there's no overriding supervision of prosecutors. You'll see that throughout the book also. Their discretion is virtually unbounded. We like to think of the grand jury system as being one that protects citizens, but it doesn't. Grand juries are virtually a rubber stamp for prosecutors. There's hardly a prosecutor in the country who couldn't get an indictment against a potato out of a grand jury if that's what they wanted to do, or get a case no-billed if that's what they want.